You're going to have to get someone to look out to see if there's a car.
Okay, well, they're not going to sit directly outside it because it's a prison threatening my family.
Right, okay, so what's your name, please?
Lenny Scott.
Is that Lenny Scott?
Yeah.
Lenny, what's your date of birth, love?
15th to the 10th, 1990.
And who's made the threat?
Elias Morgan. He's described my family and me to a T. Described my house. He said he's had them there just ready for because it's over. I've nicked them for a phone.
Ah, right. Okay.
He's until I drop that. He said to stay in there, and they're just going to constantly be around my house and.
Right. Okay.
Just in fear for my family's life. That's all.
Okay. And has he described the vehicle at all?
No, he hasn't. He said he's got lads everywhere, so he says he's described my vehicle and he's described my house and what my girlfriend and twin boys look like.
I turn to the features which aggravate the seriousness of this offence. In addition to the very significant degree of planning, is that this was a revenge killing of the deceased for what he did lawfully as part of his duty as a serving prison officer. There is an important public interest in making the killing of prison and police officers in the course of their duty exceptionally serious. This is expressly reflected within Schedule 21 of the Sentencing Act 2020. Whilst the deceased was not acting in the course of his duty when he was murdered, because he was no longer a prison officer, the killing was carried out because of what he lawfully did when he was acting in the course of his duty. It was revenge threatened by you when the deceased was a prison officer. The public interest in making the murder of former prison and police officers for their lawful actions while serving officers must require, in my judgment, sentencing on the basis that it is of particular seriousness to a very high degree. Whilst the prosecution have argued that this offence must be treated as exceptionally serious because it should fall within paragraph 2, subparagraph 2c of Schedule 21 of the 2020 Act, I am not persuaded that is correct. There is an obvious difference in seriousness between the murder of a prison or police officer whilst in the course of their duty and one which is not. Further, it is not without significance that the identification of the fact of the murder being in the course of duty was important prior to the amendment of Schedule 21 in 2015, when it became included in the highest level of seriousness. It reflects the greater seriousness of being a murder whilst the officer was performing their duty. Nor do I find that the overall circumstances of this murder leads me to treat this case as one requiring a whole life term, rather than of a very high degree of particular seriousness with a 30 years minimum term starting point and a substantial increase in that term. I have come to the conclusion that as serious as this murder was, it does not require the imposition of a whole life term. Elias Morgan, you are aged 35. You have previous convictions for offences of theft, burglary, conspiracy to rob, drugs and causing serious injury by dangerous driving between 2005 and 2016. I do not find, in the circumstances of this offence, that your previous convictions significantly affect its seriousness. I have not found there to be any significant mitigating factors which might reduce the seriousness of this offence. None have been advanced by Miss Goodwin, King's Counsel, whom you have instructed to make no submissions on your behalf. Stand up. The sentence that I am required to impose on you for this offence of murder is imprisonment for life. I am also required to fix the minimum term which you must serve before you might apply for release on licence by the parole board, which alone will determine when that may happen. Upon your release, you will remain on licence for the rest of your life and be subject to recall to custody if you breach the terms of your licence. The starting point for your minimum term must be one of 30 years because you committed this murder with a firearm. As I have already explained, the factors which make this offence more serious mean that I must increase that minimum term substantially. Had you committed this offence while the deceased was still a serving prison officer, I would have made you the subject of a whole life order. The fact that the deceased was not still a serving police officer has caused me to step back, but the minimum term must be very substantial, which I determined to be 45 years, less 452 days being the time which you've served on remand in custody. Accordingly, for this offence of murder, I sentence you to imprisonment for life with a minimum term of 43 years and 278 days. You will pay the statutory charge in the appropriate amount, which will be entered on the court record. Take him down.